Pursuant to Florida statutes, a person with custody of a will is required to file the original will with the clerk of court within 10 days after receiving information that the individual is deceased. People often believe that if there's a will, then that means there's no need to file a probate case. But this isn't true. A will contains the names of the beneficiaries, and it contains further instructions regarding how the decedent wants his probate assets distributed. Most times the court will follow the instructions for distribution laid out in the will. However, sometimes it's possible that the will attempts to make transfers that are not permitted by Florida law. This usually happens by mistake when the decedent attempted to draft a will without seeking advice from an attorney. If there are probate assets to distribute, then it's likely that some form of probate will need to be filed. Each situation is different and must be analyzed to determine whether a probate administration will need to be filed. Many times people die without a will. A probate case will likely need to be filed if a person dies without a will and there are probate assets to be distributed. If there's no will, then the deceased individual's assets will pass through intestate succession. This means that Florida law determines which persons are entitled to receive what portion of the decedent's probate estate. The law is very specific about who is to receive what property. The law may change over time. The current applicable statutes for intestate succession can be found on the website. If you have additional questions, contact me now for a free initial consultation.